So with that said, I want to now turn it over to our, excuse me, our attorney from KBR's attorney from the Tampa office location, one of the partners of the firm and the lead attorney at the Tampa office. This is Kerstin Henze. Kerstin, good morning, my friend. How are you today?
Good morning, Jeff. Thank you so much.
You're
All
very
right, folks. Well, as Jeff mentioned, I'm Kerstin Henze. I'm one of the attorneys with the law firm of Kaye Bender Rembaum. For those of you who are not familiar with the firm, we are an exclusive community association law firm. So that means that we represent exclusively condominium, homeowners, and cooperative associations. Our main office is located in South Florida in Pompano Beach, Florida, but we do have other locations throughout the state, including Palm Beach Gardens in the Orlando area. And then I'm located on the West Coast. Our office is in Tampa. So I have been with the firm since 2010 and practicing law for 17 years or so. All right, well, today we're going to tackle the HOA Board Certification class. So let me try to share my slides. Hold on a sec.
and while Kirsten's doing that, please don't confuse the Q&A module with the chat module, two different things. So what I would like everybody to do right now while Kirsten's setting up, press the chat button at the bottom of your Zoom interface, simply so it appears. It's going to say chat is disabled for you. There's nothing for you to enable, okay? Again, I'm going to repeat, there's nothing for you to enable. Even though it says chat is disabled, we can still send information your way, and that's where we're going to place the link for the evaluation later on, okay? And again, I'll go over that much more slowly later on to be sure everybody is familiar with the process. And John, no, your cameras and microphones are disabled. Way too many people here. We would have a gazillion squares on the screen if this was traditional Zoom meeting. This is the webinar platform. Only Kirsten and I can be seen and heard. You communicate by typing questions in the Q&A, and we'll get to questions and answers at the end. Kirsten will do as many as we can. We won't get to all of them, but we'll do some questions at the end. You can place additional questions in the evaluation later on. Looks like Kirsten's all set up. Back to you, my friend.
All right, thanks, Jeff. Okay, just little housekeeping. For the HOA board certification class, there is nothing in the statute that requires this class to be 4 hours long. Okay, that is for condominium association.
Thank
So
goodness.
you are, if you currently reside in a condominium association, like this is not the class for you. This is only for homeowner associations, which are governed under Chapter 720. Okay, this class, because it's not required to be 4 hours, so it'll probably run about an hour and a half to 2 hours. Okay, so that's what you can expect for today. All right, well, why are we here? We are here because the legislature passed laws actually several years ago requiring board members to be certified. Okay, so that has been in the books for, several years. The new requirement that just went into effect July 1st of 2024 now says that you have to complete an educational curriculum or board certification class within 90 days of being elected or appointed. So no longer suffice for you to just sign a certificate saying that you've read your governing documents and will uphold them to the best of your ability. Now, if you are a newly elected board member, you have to complete this board certification class within 90 days of being elected or appointed. Now, your certification is valid for up to 4 years. And then a director has to complete this class again every 4 years. Now, for those of you who have been on the board prior to July 1st of 2024, the unofficial position of the DBPR is that you have up to 4 years to complete this class. That's only if you have been on the board prior to July 1st of 2024. If you were elected after July 1st of 2024, then you have 90 days from being elected or appointed to complete this class. Now, The board certification class has to include or address certain materials, including financial literacy and transparency, record keeping, levying of fines, and then notice and meeting requirements, all of which we will be discussing throughout the course. Now, a director who does not timely complete this board certification class is suspended from the board until he or she complies, and the board can temporarily fill the vacancy during that period of suspension. Now, the association has to retain the certificate for each director who completes this class for 5 years after the director's election. However, the statute does provide that the failure to have this certification on file does not affect the validity of any board action. Okay, so in addition to the board certification class that you have to do as a newly elected or appointed director, you also have continuing education requirements, and the amount of continuing education hours that you have to fulfill will depend on the size of your community. So if your community has fewer than 2,500 parcels, you have to complete an additional 4 hours of continuing education annually. Okay. If your community has 2,500 parcels or more, then you have to complete an additional 8 hours of continuing education annually. Okay, so that's in addition to this board certification class. All right, moving on. The next slide will talk about Chapter 720 of the Florida statute, the purpose, application, and conflicts. All right. So just a quick distinction of, a homeowner associations and a condominium association. So condominium associations are governed under Chapter 718 of the Florida statute. HOAs are governed under Chapter 720 of the Florida statute. Now, HOAs exist with or without enabling legislation, and they're also a creature of common law. That means that most of the law that governs homeowner associations is really developed by judges, right? A case ends up in court, judges make laws, and then we apply those laws to the issues at hand. Now, also HOAs have what it's known as common areas, right? So you have individual parcels, and then you have common areas which are typically owned, maintained, and certainly operated by the association. So anything outside of the owner's parcel. Condominium associations have common elements, okay? That's the term used in the condominium setting. Now, another distinction, HOA board of directors decide issues regarding alterations to the parcels, and that's typically governed by the governing documents, unlike condominium associations where you may have heard of the term material alterations, and that is something that is specifically governed in Florida statute. Now, Chapter 720 of the Florida statute is what applies to HOAs, but what law applies, right? So that is going to depend on whether or not your declaration contains what is known as Kaufman language. Now, Kaufman language means or refers to the words as amended from time to time, which you'll typically find at the end of the reference to the year, which typically you'll find at the, within the first, second page of your declaration. You might have, typically you'll see a provision that says something to the effect of that this community or this association is governed under Chapter 720 of the Florida statute, and then it might say as amended from time to time. So what that means is that any substantive changes to the Florida statute that the legislature makes will apply retroactively to your community, okay, without having to make any changes to your declaration. And substantive changes are changes that affect vested rights of owners. So, for example, many of you are aware that in 2024, the legislature passed certain laws regarding commercial vehicles, right? 720 now says that you can't prohibit a work vehicle from being parked on a driveway or anywhere on the streets where owners are allowed to park. Well, whether or not that particular provision in the statute applies to your community will depend on whether or not you have Kaufman language. If you do, then yes, that provision applies to your community and you will be subject to Chapter 720 with regard to work vehicles. If you do not have Kaufman language, and I encourage you to discuss this in more detail with your legal counsel, if you do not have Kaufman language, then a constitutional argument that can be made is that this change in the Florida statute does not retroactively apply to your community, in which case the law that applies is the law that was in effect when your declaration was recorded. And the basis of that constitutional argument is a premise in the law that says that the legislature cannot make laws that impair existing contractual rights. Well, as you may be aware, your declaration of covenants is essentially a contract between owners that purchase in the community and the association. It is the document that contains your covenants and your use restrictions. So it is a contract. And so the legislature can't, make laws that impair covenants and restrictions that are already existing in the contract, unless you have Kaufman language in your declaration. Okay, so this is, certainly not an easy concept to grasp, and so requires a lot of analysis, and therefore I encourage you to discuss this issue in more depth with your legal counsel as to whether or not certain changes to the statute apply to your community. I will say that there are also procedural changes that the legislature adopts to Chapter 720 of the Florida statute. And those relate essentially to procedural issues, how things are done. For example, if the legislature makes a change to the election process or to the fining process, well, those are more of procedural changes. And so procedural changes in the statute will apply to your community regardless of whether or not you have Kaufman. So I will leave it at that. I've provided here definitions of what procedural laws and substantive laws are. You can read that at your leisure. Okay. So in addition to Chapter 720, there is one other statute that governs HOAs, and that is Chapter 617 of the Florida statute. And that is the chapter that governs all not-for-profit corporations in the state of Florida. So as you may be aware, your association is a not-for-profit corporation. Okay, so it is governed under Chapter 617. Now, in the event of a conflict between the provisions of Chapter 617 and the provisions of Chapter 720, the provisions of Chapter 720 will apply over the provisions of Chapter 617. All right. And now conflicts between the governing documents. Well, you have three documents that consist of what are referred to as governing documents. They consist of your declaration of covenants, or it might be called declaration of restrictions. You have the articles of incorporation, and then you have bylaws as well. So your declaration is what I've already discussed, that is your supreme document, right? It's the contract between owners that bind to your community and the association, and it's a document that's going to contain your use restrictions. Can you park a work vehicle or not? Are you allowed to have pets, etc.? The articles of incorporation and bylaws are documents that essentially set out the corporate structure of the entity. So it will address things like, who are the members of the association, who qualifies to serve on the board of directors, who can be officers. It will address issues like resignation. It will certainly address elections, and you could have additional provisions, okay? Now, in terms of hierarchy, the declaration is supreme. Okay, and that will always prevail over the articles and bylaws. Now, in the event of a conflict between the articles and the bylaws, the articles will control. Okay, and a common example of where you could have a conflict between articles and bylaws, for example, is when it talks about qualification of directors. So you might have articles of incorporation that are silent as to who qualifies as a director, who can be a director of your board. The bylaws might have a provision that says only owners are qualified to serve on the board. Well, when you have a conflict like this, where the articles are silent, don't impose any restrictions on qualifications, but the bylaws impose a restriction. Well, the articles will control over the bylaws, which means since the articles are silent, there are no restrictions on who can serve on the board. Okay, so you'll want to have your legal counsel review the articles and bylaws for these types of conflict. And if there are conflicts, then I encourage you to consider amending to remove the conflict. All right, let's move on and talk about membership meetings. All right, so under the umbrella of meetings, okay, there are going to be two sub-umbrellas. Right? There's going to be meetings of the membership, and then there's going to be meetings of the board of directors. Okay. So when you say, and I hear this all the time from clients, we're going to have an association meeting. Okay. Well, is it going to be a meeting of the board of directors, which is a meeting where the board votes and takes action? Or is it going to be a meeting of the membership? In other words, a meeting where owners get to vote. Okay. So if you're going to have a meeting where, for example, you are reporting, the affairs of, the current state of affairs of the association, and all the committees present, their reports, and owners are not really voting on anything, then that's not a membership meeting, right? Okay. So under the umbrella of membership meetings, there are two types of meetings. There is the annual membership meeting, and then there are special membership meetings. If nothing else, the one and only meeting that you will have of the members is called the annual membership meeting. And it is at this meeting that you will have your election of directors. So that's the one meeting you're absolutely required to have. Okay. And the association has to hold a meeting of its members annually at the time, date, and place that is fixed in your bylaws. So you've got to look at the bylaws as to when you have to hold your annual meeting. And you might have a provision that says the annual meeting of the members has to be held on the third Thursday in December. Okay. So if you have something like that, that's when you have to have the meeting. As a practical tip, you might want to consider amending such a provision and instead replace it with a provision that gives the board the flexibility to determine the date, time, and location of the meeting. Okay. Now, special membership meetings or any other membership meeting of the members other than your annual meeting. So you might call a special membership meeting on anything for which you need an owner vote, such as, for example, if you're considering amending any of your governing documents. Typically, that requires a vote of the members. And so, unless the owners are voting on those amendments at the annual meeting, you will call a special membership meeting for that vote. Now, special membership meetings, they're going to be held when called by the board of directors or when at least 10% of the total voting interest of the association petition a membership meeting, unless you have a different percentage in your governing documents. And that is something you'll typically find in the bylaws.
Kirsten, just a quick interruption because it's coming up a lot. I just want to try to nip it in the bud. Folks, this course today is for HOA certification. Please don't confuse that with continuing education. Neither Kaye Bender Rembaum nor any other education provider in the state of Florida has yet to receive direction about getting CEU classes approved. Okay. Now, even if you've taken this class before in past years and you don't need it for maybe for another few years, it's still a good idea to stay and listen, even if you are already certified. because this class is always updated annually with the latest and greatest coming out of Tallahassee. All right, so just keep that in mind. This is certification. CEU classes have not yet been determined, even though they put it into the law almost a year ago. Back to you.
All right. Agendas. For annual membership meetings, unless your governing documents require otherwise, the notice of the annual meeting does not need to include agenda. However, we highly encourage that any membership meeting notice include the agenda of all the items that will be discussed and voted upon at that meeting. Special membership meetings, yes, must include an agenda item. Notice requirements. All notices must provide the date, time, and location of the meeting. And if the bylaws do not provide for giving notice to members, then you have to either mail, hand deliver, or electronically transmit notice of the membership meeting no less than 14 days before the meeting. Okay. The statute does require that evidence of your compliance with this 14-day notice be undertaken by an affidavit. So the person that provided the notice has to sign an affidavit attesting that they've complied with the notice requirement. And then the notice and your affidavit of mailing do become part of the official records of the association. Now, keep in mind with electronic transmission, you only email notices to those owners who have officially consented to receiving notice electronically, such as via email. Okay, so make sure you have a written consent from that owner. If you don't have written consent from owners to receive notices by email, then you have to provide them with formal notice by one of the other methods, either by mail or hand delivery. Okay. And that is essentially what this slide says. Now, email addresses and fax numbers provided by members who have consented to receiving notices electronically must be removed from the association records when the member revokes consent. Keep also in mind that if an owner has consented to receiving notices electronically, then those email addresses or fax numbers do become part of the official records and can be accessible by other owners. Now, in addition to sending notices to members in one of the other ways, the board can also adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed circuit cable television system serving the association. Now, obviously, this will apply to those associations who do provide bulk services to the community. So if this is not one, if this does not apply to you, then don't worry about it. This is just an alternative way of providing notice. Now, website requirements by January 1st of 2025. So this deadline has since come and gone. An association that has 100 or more parcels now has to post notice and agendas of membership meetings at least 14 days before the meeting. All right, so hopefully all of you to whom this applies have already established your website. And so just be aware that now you have, in addition to providing notice of the membership meeting to the members, you have an obligation to post a copy of that notice with the agenda on that website. In addition, if there's a document that is associated with that meeting, you have to also post a copy of that document with the notice at least 7 days before the meeting. So, for example, if you're looking for owners to vote on amendments to your governing document, that amendment should have been provided to all the owners, right? So they can see what the amendment is. You would have also provided them with a limited proxy. Again, those documents will then have to be also posted on the website. Members' right to participate. Owners have a right to attend membership meetings as well as to speak at any meeting with reference to all items open for discussion and all items included on the agenda. And regardless of anything to the contrary provided in your governing documents, an owner has the right to speak on any of these items for at least 3 minutes. Now, the association, under the statute, does have the authority and may adopt written reasonable rules governing the frequency, the duration, and other manner of owner statements, which rules must be consistent with the above provisions. So if you want to give owners 5 minutes to speak as to any agenda items or items open up for discussion, then adopt a rule in that regard. Okay, it just can't be less than 3 minutes. Membership meetings have to be held at a location that is accessible to physically handicapped persons if it is requested by a physically handicapped person who has a right to attend the meeting. And then owners can also tape, record, and videotape membership meetings. Okay, and the board may adopt rules governing the taping of meetings. Quorum requirements. So unless there's a lower number provided in your bylaws, quorum for any membership meeting of an HOA will consist of 30% of the total voting interest. Okay, so if you have bylaws that say quorum is a majority of the membership, well, again, the statute says unless you have a lower number in your bylaws, quorum is 30%. So you would default to 30%. If your documents say that quorum is 10%, then that is the controlling quorum requirement for your community. Now, in terms of decisions, unless otherwise provided in your governing documents, decisions that require vote of the members must be made by at least a majority of the voting interest present in person or by proxy at a meeting at which a quorum has been attained. So what that means is, let's say you have a community of 100 parcels, and let's say your quorum is 30%. The first thing you do at any meeting is establish quorum, the minimum number of owners that have to be present in order to proceed with the meeting. Assuming you have achieved quorum, and let's say the minimum number that showed up at that meeting is 30% of the 100 owners. Well, then in this case, majority of the voting interest present in person or by proxy means a majority of the 30% of the owners that are actually there, present and voting. Okay. Proxies. So owners do have the right to vote in person, right? Or by proxy if your governing documents allow them to vote by proxy. To be valid, the proxy has to be dated, include the date, time, location of the meeting, and then be signed by the authorized person who executed the proxy, typically the owner or the voting representative for the parcel. Now, the proxy is effective only for the specific meeting for which it was originally given, as well as any adjournment of that meeting, and expires 90 days after the date of the original meeting. So what that means is that, let's say you conduct a special membership meeting on June 1st for purposes of amending your governing document. And let's say on the date of the meeting, you count the proxies and the in-person votes, and you see you don't have enough votes to pass the amendment. Well, the proxy is good for 90 days from that June 1st meeting. That means that you can recess and reconvene that meeting as many times as necessary up to that 90th day deadline for you to then, collect the necessary votes. There is a process to recess and reconvene the meeting, and I encourage you to speak with your legal counsel about how to go about doing that, so that it's properly reflected in your minutes, and you avoid a legal challenge to that meeting. Because remember, once you adjourn the meeting, that means that the meeting is effectively over. So if you didn't get the votes you need on that amendment, you would need to start the process again. Now, proxies are revocable at any time by the person who executes it. And any proxy holder may appoint a substitute proxy to act on his or her behalf. And a copy of the original proxy can be used if it is a complete reproduction of an entire proxy. So Owners can email their executed proxies, can mail it, can send it by fax. Either of those methods is acceptable. I would just say at some point, if you would ask the owner to provide you with the original proxy to keep in the official records, that would be even better. All right, there is a distinction between general and limited proxies. Both proxies, general and limited, can be used to establish quorum. General proxy typically is sent out with the annual meeting if there's really nothing else for owners to vote other than on elections. Limited proxy is a proxy that's really going to identify the exact issues that you want owners to vote on. Okay, so it will spell out the question, do you want to vote for, let's say, amendment to Article 3 to the declaration, yes or no? So that's what the limited proxy will include. Okay, electronic voting. I'm not going to talk about in detail of the process of instituting electronic voting. But this refers to essentially the option for owners to cast a vote electronically via some kind of electronic voting platform. And there's a number of vendors out there, including but not limited to Get Quorum. So if this is something that you're interested, then I would speak to your legal counsel or your property manager about getting some proposals from some of these vendors. But essentially, if the board wants to allow or have the option for owners to vote electronically, then that is a decision that the board can make. On a board vote alone, you don't need membership approval to institute e-voting in your community. It does require a board meeting. And the statute says that the notice of the meeting at which the board is going to adopt a resolution in instituting e-voting has to be provided at least 14 days prior to the meeting. The statute also tells you exactly what that resolution needs to reflect. And then once you, as a board, duly adopt e-voting into your community, the second part to this is that owners have to opt into the system. So they have to consent, and they can consent electronically to voting, they need to consent to e-voting on any action before the membership in the future. And once you give them that option, then essentially anytime you need owners to vote on a particular action, owners who opted into the e-voting system, they get to vote electronically. Those owners who did not opt into the system, essentially you would have to provide them with notice and the limited proxies the old-fashioned way, through mail, hand delivery, or electronically, if they consented to receiving notices electronically. Now, the statute also outlines basically all the requirements for the e-voting platform to meet in order to comply with the statute. I'm sure all the vendors out there that provide the service comply with these requirements, but just so that you're aware, and you can read this at your leisure. All right, let's move on to elections.
And good opportunity for a quick clarification. You see me answering a lot of questions. Just keep note that I'm not ignoring the ones I haven't answered. I can only answer the ones that don't require to have an ESQ after my name. So keep that in mind. Kerstin, back to you.
Thanks, Jeff. All right. A vacancy on the board that's caused by the expiration of the director's term must be filled by election. And as I mentioned earlier, elections have to be conducted on the date of your annual membership meeting. And importantly, elections have to be conducted in accordance with the procedures set forth in your governing documents. So I see this all the time where clients are conducting elections that are not in accordance with the procedure set forth in the bylaws. If you are one of those boards that are conducting elections not in accordance with your bylaws, just be aware that doing so can subject the election to a successful legal challenge. Okay, so if your bylaws contain an election system that you're just not adhering to, or it's archaic, or just doesn't meet or suit your needs, then you would need to amend your bylaws to institute an election voting system that you that you like or prefer. Okay, so an election procedure is not something that you should be adopting as a policy or as a rule. Rather, it has to be an amendment to your bylaws. Unless otherwise provided in the governing documents, a quorum of the members must be established in order to conduct an election and any other business of the association. So unlike with condominium associations where you don't need a quorum to conduct an election, with HOAs, that is the first agenda item on your notice. You have to establish quorum in order to proceed with your election, as well as to proceed with any other agenda item. If you do not get quorum on the date of your annual election meeting, then you cannot have an election, okay? Which means that the existing directors, their seats effectively roll over for another term unless any director resigns. Unless otherwise provided in your governing documents, directors are elected by a plurality of the votes cast by eligible voters. So plurality means whoever gets the most votes, not just the majority. All right, candidate eligibility. All members are eligible to serve on the board unless they're otherwise disqualified. And according to Chapter 720 of the Florida statute, a person who is delinquent in the payment of any monetary obligation to the association on the day that he or she could last nominate himself or herself to the board cannot be listed on the ballot. Okay, as well as any person who has been convicted of a felony in Florida or in a U.S. district, and whose civil rights have not been restored for at least 5 years, also is not qualified to run for the board. And then a person who has pending criminal charges for forgery of a ballot envelope or voting certificate, felony theft or embezzlement offense involving association funds, or tampering with physical evidence, obstruction of justice, they may not be elected to any board. Now, with HOAs, a member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. However, the statute does provide that if the election process set forth in your governing documents allow candidates to be nominated in advance of the meeting, then the association is not required to have nominations on the date of the meeting. Okay, so again, look at your bylaws to see what is the election process that you are required to follow. If you want owners to have the option to nominate themselves in advance, as well as to dispense with nominations on the date of the annual meeting, then you would have to amend the bylaws to provide for that. Otherwise, owners are entitled to nominate themselves on the date of the election meeting. Now, on election day, an election is not required unless there are more candidates are nominated than vacancies exist. If an election is not required because there are either an equal number or fewer qualified candidates than vacancies exist, and if nominations from the floor are not required, then the qualified candidates commence service on the board at the annual meeting, regardless of whether a quorum is attained at the annual meeting. Now, in terms of voting, members have the right to vote in person or by proxy unless otherwise provided in the governing document. So you got to look to see if owners can vote for candidates by proxy. Okay, unless there's a restriction, they can. Now, if the governing documents permit voting by a secret absentee ballot, then the statute says that you have to treat those secret absentee ballots in the way that condominiums treat them, which means that The ballot has to be placed in an inner envelope without any identifying markings. Okay, and then that inner envelope then has to be placed inside another envelope, which is referred to as the outer envelope. And then on the outer envelope, the owner who's casting the ballot has to include their names, their property parcel address, and then sign the envelope. Okay, and that's how you would cast a secret absentee ballot. So you have to follow those statutory requirements. And that's only if your bylaws allow secret absentee ballots. If your bylaws currently don't allow that and you want it, again, you'd have to amend the bylaws. And then in terms of the term of directors, unless the bylaws provide otherwise, directors serve a 1-year term. Now, for election challenges, any challenge to the election process has to be commenced within 60 days after the election results are announced. Typically, election results are announced on the date of the annual election meeting. And so any election challenge really has to be commenced within 60 days of your annual election meeting. Any election dispute between a member and the association has to be submitted to binding arbitration with the Division of Condominium, okay, which is the regulatory agency that governs condominium associations. They do not typically have jurisdiction over HOAs, except for limited instances, such as elections. So you'd have to arbitrate elections with the division, or you can file an election dispute in court. And then election disputes submitted by binding arbitration with the division have to be conducted in the manner set forth in the condominium statute. All right, election of officers. Generally, officers are appointed by the board immediately following the election of directors at the organizational meeting. Okay. If otherwise, you'll have probably a provision in your bylaws that says that officers have to be appointed within a certain time frame of the annual meeting. So again, you can either do it within that time frame or immediately following the annual meeting. Now, directors cannot vote by proxy or by secret ballot at board meetings, except directors can cast their vote for an officer by secret ballot. So they can elect officers by secret ballot. And by that, I mean, literally, you can have a Post-it note where each director, writes his, writes the name of the individual that they're voting for, president or whatever other officer position there is. So it doesn't have to be some kind of official ballot. There is also no prohibition against changing officers midstream or midterm, which means that if the treasurer is not doing what they're supposed to, the board always has the option in the middle of the term to remove the treasurer from the treasurer's position and then appoint another individual to act as the treasurer. Now, if the treasurer is also a member of the board, if he is or she a director, that the board cannot remove a director from the board. So the treasurer will remain as a director. He or she will wear their director hat. They would just not be a treasurer if you've appointed someone else. All right, fraudulent voting activities. A person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. And we've identified all of the acts that are set forth in the statute, but essentially willfully and falsely swearing to affirming an oath of affirmation, or willfully procuring another person to falsely swear or affirm an oath or affirmation in connection with or arising with a voting activity, perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote cast, so forth and so on. And you can read these in more detail at your leisure when you get the slides. Now, effective July 1st of 2024, each of the following acts constitutes a first-degree misdemeanor. knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent election voting activity and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. In terms of vacancies on the board, unless otherwise provided in the bylaws, any vacancy occurring at the board before the term expires may be filled by an affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. So what that means is that if you have a board of 5 directors, and let's say 4 directors have resigned, and you only have one remaining director on the board, obviously there's no quorum of the board, and so without a quorum of the board, you cannot conduct business. So the one and only function that that sole remaining director can do is appoint enough of the fill enough of the vacant seats to at least constitute a quorum on the board. So once he's appointed at least 2 other directors, now you have quorum, and now you can conduct association business. In the alternative, the board can also hold an election to fill the vacancy, in which case you have to follow the election procedures that are set forth in your bylaws. And then, unless otherwise provided in the bylaws, a board member appointed or elected to fill a vacancy occurring on the board before the expiration of the term serves only for the unexpired term of the seat being filled. All right, so let's shift gears now to board of directors. So the officers and directors of an association have a fiduciary responsibility to the owners. That means that they have to act reasonably. And you get to exercise the reasonable business judgment of the board in making decisions. Now, unless otherwise provided in the governing documents or the law, associations' powers are exercised by the board. That means no single director should be making decisions for the board. Okay. Now, directors cannot vote by proxy or by secret ballot at board meetings. The only exception is that they can vote by secret ballot only when electing officers. Now, members of the board can use email as means of communication. You just cannot cast a vote on association matters by email. You can discuss issues via email, just can't vote on things via email. All board meeting notices, just like with membership meeting notices, they have to include the date, time, and location of the meeting, and have to identify all agenda items. Now, unless otherwise provided in your bylaws, most board meetings will only require a 48-hour posted notice. So you would post notice of the meeting with your date, time, location, and agenda item at least 48 hours prior to the meeting, unless there's an emergency. And then, unless otherwise provided in your governing document, notice of any meeting at which a special assessment or an amendment to the rule regarding parcel use will be considered has to be mailed, delivered, or electronically transmitted to the owners at least 14 days prior to the meeting. So if you look at your bylaws, and your bylaws require notice of the meeting at which you can adopt a special assessment to be provided 30 days in advance of the meeting, then you obviously go with the more restrictive requirement, the 30 days opposed to 14 days, okay? So just like with membership meetings, in addition to the other notice methods, the association may also adopt by rule a procedure for posting board meeting notices and agendas on association website. And any rule adopted must include a requirement that the association send electronic notice to members whose email addresses are included in the official records in the same manner as is required for notice of a meeting of the members. And such notice has to include a hyperlink to the website or the application in which the meeting notice is posted. Now, I've already discussed this, but again, by January 1st of 2025, an association that has 100 or more parcels has to have a website or an application and has to post notice of meetings, agendas, and any other document that is required by statute. Member participation at board meetings. So all meetings of the board obviously are open to all the members, except if it's a meeting between the board and its legal counsel with regards to pending or proposed litigation, those meetings would then be closed, as well as any meetings held for purposes of discussing personnel matters. Those are the two types of meetings at which owners are not entitled to attend. Now, you would still notice the meetings, right? You would just include on the notice, closed meeting with association legal counsel, for example. Members have the right to attend all board meetings, with the exception of the two noted above on the slide, as well as the right to speak at any board meeting with reference to any designated agenda items. Now, unlike members' right to speak at members' meeting, there is no statutorily prescribed time limitation for a member to speak at a board meeting, although a minimum of 3 minutes may be a reasonable rule in that regard that the board can adopt. As with membership meetings, an owner may tape record or videotape board meetings, and then board meetings also have to be held at a location accessible to physically handicapped persons if it is requested by the physically handicapped person. Now, a director, officer, committee may not directly receive any salary or compensation from the association for performing their duties as a director, officer, or committee member, and may not in any other way benefit financially except for the following. And these are straight from the statute. So while a director or officer cannot be compensated for their service as a director, the following compensation is permissible. Participation by such person in a financial benefit accruing to all or significant number of members as a result of actions lawfully taken, reimbursement for out-of-pocket expenses incurred on behalf of the association, recovery of insurance proceeds derived from a policy of insurance maintained by the association, as well as any fees or compensation that's either authorized in the governing document or by a vote of a majority of the voting interest, voting in person or by proxy at a meeting, or a developer or its representative serving as a director, officer, or committee member. Now, the statute also prohibits kickbacks. Any officer, director, or manager cannot solicit, offer to accept, or accept kickbacks, and a kickback is defined in the statute as anything or service of value for which consideration has not been provided for an officer, director, or manager's benefit, or for the benefit of an immediate family member from any person providing or proposing to provide goods or services to the association. And any director, officer, or manager who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. Now, the officer or director who violates this prohibition must also be removed from office by the board, creating a vacancy that can be filled according to law. However, an officer, director, or manager may accept food to be consumed at a business meeting with a value of less than $25 per individual, as well as may accept a service or good received in connection with trade fairs or education programs. So those are acceptable. Now, a director or officer charged by information or indictment with any of the following crimes must be removed from office: forgery of a ballot envelope or voting certificate, theft or embezzlement involving association funds or property, tampering with physical evidence, obstruction of justice, and any criminal violation under the Homeowners Association Act. Now, the board must fill the vacancy until the end of the period of the suspension or end of the director's term of office, whichever occurs first. However, if the charges are resolved without a finding of a guilt or without acceptance of a plea of guilty, the director or officer must be reinstated for any remainder of his or her term. Another grounds for immediate removal is if a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association is deemed to have abandoned his or her seat on the board, which creates a vacancy on the board to be filled according to law. So this is an automatic abandonment of the director's seat. So it's not something that the board needs to vote in order to ratify. All right, I think this is the last section under the board of directors, which is conflicts of interest. So directors and officers have to disclose to the association any activity that may reasonably construed to be a conflict of interest at least 14 days before voting on the issue or entering into the contract that is the subject of the conflict. Now, under the statute, there is a rebuttable presumption that a conflict of interest exists if any of these two things occur. Either the director, officer, or relative of the director or officer enters into a contract for goods or services with the association, or the director, officer, or relative of a director or officer holds an interest in an entity that either has entered into a contract or is looking to enter into a contract with the association. Now, the statute doesn't necessarily prohibit these contracts, but it does provide a process by which these contracts have to be properly approved by the board. So the proposed contract with the director has to be fully disclosed to the board, and the disclosure entered into the minutes of the board meeting at which the contract will be considered, and then it has to be voted upon and approved by 2/3 of the directors present. The contract or the transaction with the director has to be reasonable and fair. And then at the next regular or special meeting of the membership, the existence of the contract or transaction with the director has to be disclosed to the membership. And then upon a member's motion, the contract may be canceled by a majority vote of the members who are present at the meeting. And if the contract is canceled at the membership meeting, then the association would only be liable for the value of goods or services that were provided prior to the cancellation, and the association would not be on the hook for any termination fees or any liquidated damages. Okay, moving on to official records. All right, so we've just done about an hour. So going into our second hour. All right, the official records include, and this is the laundry list that comes straight from the statute. Okay, so this is what your official records consist of. Obviously, all of your governing documents, minutes of meetings, financial accounting records, okay, ballots, sign-in sheets, anything that is associated with a membership vote. It's all in the statute. Now, these official records have to be maintained for at least 7 years unless your governing documents require a longer period. Now, almost everything has to be maintained for 7 years, except bids received by the association for work to be performed have to only be kept for 1 year. And then the only other records that need to be kept for a year are, let's see, back here in this slide, ballots, sign-in sheets, voting proxies, and all other papers and electronic records relating to voting by owners. So for example, for your election, all paperwork regarding your election, those have to be kept for 1 year. Now, effective July 1st of 2024, the association must adopt written rules governing the method or policy by which the official records are to be retained and the time period such records must be retained. Okay. The statute also identifies records that are not accessible to owners, which we've included in these slides. So, for example, records that are protected by attorney-client privilege, information obtained in connection with the approval of a lease or a sale or transfer of a parcel. This obviously applies if you are one of those associations that have the ability to approve or disapprove purchasers and tenants. And so if you do, as part of your application process, you will likely receive background information on the applicant, such as a criminal or a financial credit report. And so just note that any of that documentation that is obtained in connection with the approval process has to remain confidential. And then certainly information such as our security numbers, driver's license numbers, phone, fax numbers, email addresses, and any other address other than as provided for association notice requirements. That all has to be kept confidential. Some additional records that are not accessible to owners, such as personnel records, medical records. Medical records might come into play if an owner requests some kind of accommodation or modification under Fair Housing Act. And so if an owner did submit some kind of medical records to substantiate his or her request, then those would be kept confidential. Just a little bit more here on the attorney-client privilege. Just note that, for example, whenever you request your legal counsel to provide any legal guidance on a particular issue, any communication between legal counsel and members of the board is protected by attorney-client privilege. But the only ones that can waive that privilege is the client, the board of directors. So if you want to break privilege and share a legal opinion with the members on a particular issue, that is certainly a board decision. An association may print and distribute to owners a directory containing the name, lot addresses, and phone numbers of each owner. But an owner may exclude his or her telephone numbers from the directory by so requesting in writing to the association. And an owner can also provide written consent to the disclosure of other contact information, which is otherwise not accessible to members. So if the owner consents to having his or her email accessible to the rest of the membership, then be sure to have that written consent in your records. Now, access to the official records, unless otherwise provided by law or the governing document, the official records have to be made available for inspection within 45 miles of the community or within the county. And then they have to be provided within 10 business days after you receive an owner's written request. Now, if an owner submits a request to inspect the official records by certified mail, return receipt requested, and access to the official records is not timely provided, meaning within those 10 business days of receiving that request by certified letter, there is a rebuttable presumption that the association willfully failed to comply. So what that means is that if you receive a request for inspection of records, but not if you receive the request, let's say by email or regular mail, not by certified mail, it doesn't mean that you don't have to comply. You still have to comply and give access to the official records within 10 business days. It's just that if the request is sent by certified mail and you don't provide access within the 10 business days, then there is a presumption, a rebuttable presumption that you willfully failed to comply. Now, if you don't provide access to the records within the statutory time frame, then the owner is entitled to damages. The minimum damages are $50 per calendar day up to 10 days. And the calculation begins on the 11th business day that the records were not provided. Now, a new law that became effective July 1st of 2024 is that if the association receives a subpoena for records from law enforcement, the association must provide a copy of the records requested. You have to provide a copy of the records requested within 5 business days after receiving the subpoena, unless otherwise provided by law. And you, the association, you have to assist law enforcement in its investigation to the extent permissible by law. Now, certain conduct with regards to failure to provide access to official records is now also criminalized in the statute. So effective July 1st of 2024, any director or manager who knowingly, willfully, and repeatedly means 2 or more violations in a 12-month period. So if you knowingly, willfully, and repeatedly fail to provide access to the official records with the intent of causing harm to the association or one of its members, then you commit a second-degree misdemeanor. Similarly, a person who knowingly and intentionally defaces or destroys accounting records, or who knowingly or intentionally fails to create or maintain accounting records that are required to be maintained with the intent of causing harm to the association or one of its members, commits a first-degree misdemeanor. And then any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment commits a third-degree felony. Now, the statute does give associations the right, the entitlement to adopt reasonable written rules governing the frequency, time, location, notice, records to be inspected, and the manner of inspection. However, if you are going to adopt these rules, you cannot require an owner to show any proper purpose for the inspection, or require an owner to state any reason for the inspection. So they don't have to say, I'd like to inspect these records because I want to do XYZ, or the purpose of the inspection is to, XYZ. You can't require them to explain why they're looking at particular records. And you also cannot limit an owner's right to inspect records for less than 1 8-hour business day per month. Okay, other than that, you can adopt reasonable rules regarding records inspection. Now, if an owner shows up to the records inspection with a portable device, a smartphone or a tablet or a portable scanner, you have to allow them to make copies of the official records that they're inspecting free of charge. So you can't charge the owner for making copies of records with these devices. Now, if the owner does request for the association to provide copies of certain records, then if the association has a photocopy machine available where the records are maintained, it has to provide owners with copies on request during the inspection, only if the entire request is limited to no more than 25 pages. Now, the association may charge up to 25 cents per page for copies made on the association photocopier. Now, if you don't have a photocopier, or if the records requested to be copied exceed 25 pages, then you can have copies made by an outside source like Kinko's, and then you can charge the actual cost of copying right? And just make sure that you have the receipt or the invoice from the vendor to support those copying charges. Now, the association may also charge for the costs required for personnel to retrieve and copy the records if the time spent retrieving and copying records exceed 1/2 hour, and if the personnel costs do not exceed $20 per hour. Now, personnel costs cannot be charged for records requests that result in copying of 25 or fewer pages. All right, let's quickly go through the requirements for association website. So again, by January 1 of 2025, associations having 100 or more parcels must have created a website or downloadable mobile application for the posting of association documents. Now, the website has to be accessible through the internet, and then it has to contain a subpage or web portal or other protected electronic location that is inaccessible to the general public and accessible only to owners and employees of the association. Now, if an owner requests a username and password, obviously you have to provide them with the username and password to access the website, or at least the protected information that is only accessible to owners. Now, the statute also provides for the documents. It outlines what documents have to be posted on the website. It's not all the official records, okay? And we've included here the list of the items that have to be posted on the website, so you can go through it at your leisure. The association has to ensure that the information and records which are not allowed to be accessible, they're not posted on association's website. So remember those records we talked about, which are not accessible, like medical records of owners and other information that it cannot be posted on the website. And the association's authorized agent is not liable for disclosing, protect, or restricted information unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of the information. All right. We're switching gears to amending the governing documents. Now, this is only a fraction of what we actually discussed at another webinar called Updating Governing Documents. So if you are looking to amend your governing documents, then I encourage you to attend one of these other webinars that we do specifically on this topic. But essentially,
Kerstin, aren't you doing one of these live in person for anybody who's in the Tampa area in a couple of days?
yes, I am actually. May 22nd on Thursday.
Yep, I'll go over that at the end. I just wanted to,
Yes.
for anybody in the Tampa area, I just wanted you to be informed it's light breakfast.
Yes, I totally forgot I'm teaching that.
Light breakfast at the Seminole Gardens in Tampa area. So if you're in that area or plan to be, it's a great opportunity to meet Kerstin, learn about the firm, have some bagels and donuts and coffee, and learn about updating your governing documents. You can find it at kbrlegal.com. And back to you.
Good, thank you. All right, so unless otherwise provided in the governing documents or law, any governing document can be amended by the affirmative vote of 2/3 of the voting interest. So, you know, if you're looking to amend the declaration, you need to look at the declaration to see what is the percentage of votes of member votes that you need specifically to amend that particular document. If you're looking to amend the bylaws, you got to look in the bylaws, okay? Now, if the document you're looking to amend is silent, then you need a vote of 2/3 of the owners. Now, in terms of the format, essentially you have to type up the language that you're looking to amend, and then you have to designate your changes with underlines and strike throughs. So any language that you are adding, any language that you're adding to the governing document, you have to underline. Anything that you're removing has to be removed with a strike through, okay? Now, if you are doing substantial changes to a particular section, article, or document, then the statute does provide for an alternative. So rather than underlining and striking through every single change, You can just make the changes without the underlines and strike-throughs, but you have to include at the top of the amendment the words that I have here in quotations in the second bullet point, which is, this is a substantial rewarding. See the governing documents for the current text. Now, it is possible that the particular document that you're looking to amend might require consent of mortgagees. And mortgagees being those lenders that have a mortgage on a particular parcel. So if you do, there is a statutory process that you have to follow to get mortgagee consent. And I would encourage you to get with your legal counsel if you're amending to specifically confirm what the amendment requirements are, whether you need mortgagee consent, and then to discuss the process. Now, any amendment to the governing document is effective when recorded in the public records. So make sure that even if you get membership approval, that you get those amendments recorded. And then once the amendment is recorded, the statute does say that within 30 days after recording the amendment, you have to provide a copy of the amendment to the members. In the alternative, you can also, on that notice, rather than providing a copy to the owners, you can include on the notice the book and page or the instrument number of the recorded amendment. And then let them know that if they do request a copy of the amendment, it would be provided free of charge. All right. A few gems all board members should note. So let's go through a couple of items here. All right, governmental filings. So remember I mentioned that your association is a corporation, a not-for-profit corporation. So you are going to have at least these two filings that you're going to have to do every year. One, you have to update your annual report with the Division of Corporation in order to maintain an active corporate status. This is something that typically your property manager, if you have management, your property manager will do for you. So you'd have to go on the website of the Division of Corporation, which is sunbiz.org, and then you'll electronically update your annual report. And typically this is done between January and May, usually after you've already had your election, because when you update your annual report, you will update the Division of Corporation as to who are the current board members. Okay, so that's typically when you'll update the annual report. And then your annual income tax. So although you are a not-for-profit corporation, you are not exempt from filing annual tax returns. So make sure you get with your CPA to file your tax returns. Meeting minutes. At all meetings, you have to take minutes. Now, minutes do not have to be a verbatim record of everything that took place. So, I mean, I've seen minutes that are just pages long, include a verbatim account of who said what, and that's just, that's not what minutes need to be. Minutes have to simply reflect who are present, which directors were present at the meeting, what motions were made, who made the motion, who seconded the motion, and then what was the vote. Now, if there's a particular issue that involved a lot of discussion, you might include, just a brief excerpt of what was discussed. But that should really be the extent of it, because including too much information on these minutes could also subject the association to potential legal challenge. Rules and regulations. Typically, the board can adopt, promulgate rules and regulations regarding the use of common areas, recreation facilities, and lots, if that authority is in your documents. Okay, so you'd have to look at your bylaws and your articles of incorporation to see if the board has this authority. Now, occasionally I have seen where the documents specifically require owners to also approve rules, an amendment to rules, okay? So don't just presume that this is something that the board can do. Take a look at your governing documents to see if there's any requirement for membership approval. Now, typically, rules regarding the operation of the association, as well as regarding use of community property or common facilities or recreation facilities, whatever you call them, they just notice of those meetings just need to be posted 48 hours prior to the meeting. Now, the statute does specifically say that if you're looking to adopt a rule regarding parcel use, then notice of the meeting in which you're going to adopt a rule on parcel use has to be provided to the owner at least 14 days in advance. And then in order for those rules to become effective, make sure that you always provide a copy of the rules to the owners after they've been adopted so that they know and are aware of what the new rule changes are. All right, Marketable Record Title Act. This applies to Homeowners Association. What the Marketable Record Title Act provides is essentially that your declaration of covenants or restrictions are good for 30 years, and they will automatically expire 30 years after the initial recording of the declaration. Okay, now boards do have a fiduciary obligation to preserve your covenants, and the statute, the Marketable Record Title Act does provide for several options on how to preserve the governing documents, which typically require something to be recorded in the public records, reflecting the intent and desire of the association to preserve the covenants. When you take that action, you preserve the covenants for another 30 years. So they'll be good for another 30 years, at which point you'll have to do the same thing again. Now, there are many associations where, boards we're just not aware, we're not properly advised of this time frame, and so the documents have expired. If you are in one of those communities where your documents have expired because you didn't take action to preserve them in time, well, there is still a process to revitalize these documents. It's a little bit more of a complicated process, and that process does require membership approval, and then it does require the approval of the Department of Commerce in Tallahassee. Okay, so I would encourage you to take a look at your declaration, see when it was recorded. And if you're past the 30-year mark, see if anything has been recorded in the public records within the 30-year period, preserving the documents. And if not, speak with your legal counsel about what you need to do in order to revitalize. All right, emergency powers. I really am not going to spend much time on this section. Just be aware that Chapter 720.316 of the Florida statute gives associations certain emergency powers that might be useful when there's an emergency, a declared state of emergency. So those are provided here in these slides, so you can take a peek later. Let's move on to litigation authority. So the association may institute, maintain, and settle actions on behalf of the members. Okay. Now, before commencing any litigation against any party in the name of the association involving amounts in controversy in excess of 100,000, the association must obtain the affirmative approval of a majority of the voting interest at a meeting at which quorum has been attained. Okay. Architectural control. This is one of the more controversial topics. Many of these changes went into effect last year, July 1st. So an association must reasonably and equitably apply and enforce on all owners the architectural and construction improvement standards or other published guidelines. I mean, that seems very common sense, but now it is codified. So you have to reasonably and equitably apply your architectural standards against all owners. And if the association denies an owner's request or application for modification to their parcel, you now have to provide written notice to the owner stating with specificity the specific rule or the covenant on which the association relied when denying the request or application, and then as well identify the specific aspect of the proposed improvement that does not conform to such rule or covenant. Effective July 1st of 2024, the association cannot enforce or adopt a covenant or rule that limits or places requirements on the interior of the structure that are not visible from the parcel's frontage or an adjacent parcel or an adjacent common area or community golf course. So that means that if an owner wants to remodel their kitchen or make any modifications within the parcel and you can't see them from these locations, well, you can't require the owner to submit an ARC request form and get board approval. Now, for most HOAs, if you have, single family lots, that's not a problem. But if you're an HOA that primarily consists of townhomes or units that are attached and there's a shared wall, this could be potentially problematic. Now, you also cannot require the review and approval of plans or specifications for a central air conditioning, refrigeration, heating, or ventilation system. If the system is not visible from the parcel's frontage, adjacent parcel, or an adjacent common area or community golf course, and it is substantially similar to a system that is approved or recommended by the association. Now, this section was already in effect for a couple of years. The only changes made is what I've outlined here in blue. So regardless of any covenant restrictions or bylaws, rules, or other requirements, and unless prohibited by general law or local ordinance, the association may not restrict an owner or a tenant from installing, displaying, or storing any item on the parcel, which is not visible from the parcel's frontage, adjacent parcel, an adjacent common area, or community golf course, including, but not limited to, artificial turf, boats, flags, vegetable gardens, clotheslines, and recreation vehicles. Also, effective July 1st of 2024, the association must adopt hurricane protection specifications for each structure or other improvement on the parcel governed by the association. Now, this requirement applies to all associations governed under Chapter 720 of the Florida statute, regardless of the date created, regardless of whether or not you have Kaufman, okay? You are now required to adopt hurricane protection specifications. Now, hurricane protection includes, without limitation, roof systems, permanent fixed storm shutters, roll-down track storm shutters, reinforced garage doors, impact-resistant windows, as well as any other hurricane protection product that will protect the structure. So if you don't have hurricane protection specifications for, roof or replacement of windows, now is the time to do that. The association cannot deny, once you adopt these specifications, you cannot deny an application for the installation, enhancement, or replacement of a hurricane protection by any owner which conforms with your specifications. And the association may require an owner to adhere to an existing unified building scheme regarding the external appearance of the structure. Now, vehicle restrictions effective July 1st. The association's governing documents cannot prohibit an owner, tenant, guest, or invitee from parking his or her personal vehicle, which includes a pickup truck, on the owner's driveway or any other area where the individual has a right to park. You also can't prohibit an owner, guest, or invitee from parking his or her work vehicle, regardless of any official insignia or visible designation, which is not a commercial vehicle as defined under Chapter 320. Now, I will tell you that commercial vehicles, as defined in the statute, is a vehicle that weighs at least 26,001 pounds. So unless that vehicle is a commercial vehicle, weighs 26,001 pounds, according to statute, you can't prohibit that work vehicle from parking in the community. Now, remember I discussed whether this law applies to your community. You're going to have to do an analysis with your legal counsel as to whether or not you have Kaufman language. Also effective July 1st of 2024, the governing documents cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on the parcel solely because the contractor is not on the preferred vendor list. And you also cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on his or her parcel solely because the contractor or worker does not have a professional or an occupational license. All right. Quickly moving on to budgets and reserves. So every year, the association has to prepare an annual budget that reflects your revenues and expenses for the upcoming year. Now, your budget is primarily going to consist of your operating expenses. Now, if you maintain reserves, and we'll talk about reserves momentarily, you might have a reserve component section to the budget. Otherwise, your budget is primarily going to consist of operating expenses. Now, as a practical tip, monies that are in the operating section of the budget are not restricted to any particular purpose. And therefore, the board can use monies allocated to one operating line item for other purposes as authorized in the governing documents. Okay, you're not restricted. Now, your operating expenses relate to your day-to-day operation, and I've included here just a list, some items that you might see on a budget. You might have others, but essentially administrative management fees, maintenance, repairs of common areas, taxes, insurance, and then professional fees if you have, for example, legal counsel or management or an engineer. Certainly CPA. Okay. Now, in addition to your operating expenses, the budget may include reserves for capital expenditures and deferred maintenance. And we've included here the statutory definitions of capital expenditures or deferred maintenance. And some reserve items may include pavement resurfacing if you own the streets in your community, repair improvements to certain common areas, such as, for example, replacing the roof in your clubhouse, sidewalk improvement, and you might have other capital improvement projects. Now, statutory reserves are only created upon the affirmative approval of a majority of the total voting interest. Okay, so if you have a record of a majority of the voting interest voting and creating statutory reserves, then you have to maintain these reserves in accordance with the statute, which means that they have to be funded, maintained, and then either waived in accordance with the Florida statute. If you do not have a record of owners creating these statutory reserves, then these, what you call reserves, are really not reserves as contemplated in the statute, but rather they're just operating funds, in which case you can use those funds for any bona fide association expense. Now, if you have created statutory reserves, the amount to be reserved is going to be based on the estimated remaining useful life and the estimated replacement cost of the deferred maintenance expense. Now, your reserve schedule will identify the items here at the bottom of the slide. Your reserve schedule will include the total estimated useful life of the asset, the estimated remaining useful life of the asset, estimated replacement cost, and the estimated fund balance. But again, this is only if your membership has created statutory reserves. Now, if they did, you have to fully fund reserves every year. And typically you'll have a reserve study that identifies what your reserve items are and how much you need to fund every year so that when it is time to replace that item at the end of its useful life, you have enough funds to do that. Now, the statute does allow for the statute does allow for these reserves to be waived. Oh, this is on the next slide. Just go to this slide. So the statute does permit these reserves to be waived or partially funded, so anything less than fully funded, by a vote of the membership. Okay, so if you want to give owners the option to either waive reserves for any particular year or to only partially fund those reserves for a given year, then you have to present the issue to the owners for a vote. Now it's up to the board's discretion if you want to do that or not. Okay. And then after the members vote, obviously make sure you have the voting, the limited proxies and the ballots as part of your official records to reflect the waiver or partial funding for the particular given year. And the vote that you need to obtain is a majority of the voting interest. Okay. Now, if you do maintain statutory reserves, per the statute, you can only use those statutory reserves for the particular item for which you've reserved, right? So if you've created statutory reserves for replacing the roof of the clubhouse, then that's the only thing that you can use those reserve funds for. If you want to use statutory reserves for alternate purposes, then the statute says you have to obtain a vote of the majority of the voting interest present at a meeting at which a quorum is present. You also have the option of pooling those reserves. In other words, create a pooled account for 2 or more reserve items. The flexibility that creates is that when you pool reserves, then let's say you've pulled reserves for pavement resurfacing and replacement of the clubhouse roof. And let's say you absolutely need to replace the roof, but you're a little short on the funds you need to do that. Well, you can take funds from that were allocated for the paving to fund the shortfall for the roof replacement without a membership vote. Okay, now at some point you'll have to get with your CPA and catch up on the funding, but that's the flexibility that pooling reserves offers. Now, in terms of adopting the budget, unless your governing documents provide otherwise, the meeting at which you're going to adopt the budget really only requires 48-hour notice. Okay, and there is no requirement in the statute for you to provide a copy of the proposed budget to the owners in advance of the meeting. Now, after you've adopted the budget, the association does have to provide each member with a copy of the budget or written notice that a copy of the budget is available upon request at no charge to the member. And then by January 1st of 2025, an association with 100 or more parcels now also have to post a copy of the annual budget on its website. All right, let's go through assessments. So special assessments. If the board is looking to adopt a special assessment, then notice of the meeting at which you're going to adopt the special assessment has to be mailed, delivered, or electronically transmitted to members at least 14 days prior to the meeting. Now, if your bylaws have a longer notice provision, then you go with that. Otherwise, it's just a 14-day notice. Now, the notice has to include a statement that the special assessment will be considered, as well as provide the nature of the assessment, and should identify also the estimated cost of the assessment. And then once levied, the association should send written notice to the owners that the special assessment has been adopted, how much is each owner responsible for, and then allow owners a reasonable period within which to pay the assessment. A special assessment that has not been paid by the owner can then be collected in the same manner as a regular assessment through collection foreclosure proceedings. Now, effective July 1st of 2024, any person owner can request, can make a written request to the board for a detailed accounting of any amounts that he or she owes to the association related to the parcel. And if you receive such a request, you have to provide such information within 15 business days after receiving the request. Now, after the parcel owner makes this request, he or she cannot request another detailed accounting for at least 90 days. Now, the failure of the board to respond within the 15 business days means that it constitutes a complete waiver of any outstanding fines that the person who requested the accounting, which is more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fines. To date, I have not had any client that's come to me with any issues on this particular provision. So I'm not sure if owners are using this or not, but just so you're aware. Assessments that are not paid when due bear interest at the rate that is provided in the declaration or the bylaws. So if you have one of those older documents that include a rate such as 10% or 15%, which is what I've most commonly see, then you have to go with that percentage that's in your document. If there is no rate provided, then you can charge up to the maximum that is provided in the statute, which is currently 18%. Now, you can also charge an administrative late fee not to exceed $25 or 5% of the amount of each installment if it's permitted by your declaration or bylaws. So while the statute provides for an administrative late fee, you as an association can only charge it if you have the authority specifically in your declaration. So declaration or bylaw. So just be aware of that. And then the association is entitled to collect attorney's fees and costs incurred in collection of any delinquent assessment. Now, application of payment. Any payment received by an association has to be first applied to any interest, then administrative late fees, and then to any costs and reasonable attorney's fees, and then lastly to the delinquent assessment. Now, if you are looking to start a collection action against an owner who is delinquent on his or her assessments to the association, the statute does say that the association cannot require payment of attorney's fees related to this past due assessment without first providing the owner with what is called a written notice of late assessment, or NOLA. So in other words, before you can turn over the collection matter to your attorneys and before your attorney starts collections, you, the association, and typically through management, have to send this written notice of late assessment to the owner, letting them know that they are delinquent on a certain amount, identify that specific amount, and then you have to give them 30 days to pay before you turn over and proceed with collections. Okay. Now, the notice of late assessment has to be sent by first-class U.S. mail. Doesn't have to go by certified mail. And it has to go to his or her last address as reflected in the association record. And if that address is not the parcel address, then you also have to send the notice of late assessment to the parcel address. Notice is deemed to have been delivered upon mailing. Now, once you send that notice, you also have to have an affidavit completed by the individual who provided that notice attesting to the mailing. And if you are a client of ours and you turn over a matter for collections, we will definitely request from you a copy of that notice of late assessment as well as a copy of the affidavit to make sure that you've complied with the statute. Now, before the association can file a claim of lien, the association has to provide written notice of the intent to lien and give the owner 45 days to pay the delinquency before claim of lien is filed. Okay. Now, once the claim of lien is filed, before the association can foreclose, the association has to provide the owner another notice of the intent to foreclose and giving the owner another 45 days to pay the delinquency before you can even start with foreclosure action. So as you can see, with the 30-day notice under the notice of intent, with the notice of late assessment, then the 45-day notice of intent to lien, and then an additional 45-day notice of intent to foreclose, you're now looking over 100 days before you can even file foreclosure. Okay, so don't sit on these delinquent accounts. Now, most of you are aware that the statute provides that if there is a mortgage on a parcel and that mortgagee forecloses and takes title to the parcel, then that mortgagee, according to statute, is liable to the association for the lesser of either assessments that accrued during the 12 months immediately before taking title, or 1% of the original mortgage debt. Okay, so that is the what is referred to as the safe harbor amount that a mortgagee would be liable to the association if they foreclose and then take title to the parcel. Now, as a practical tip, you might have in your declaration a provision that provides that the mortgagee owes nothing to the association, for any delinquency that accrued prior to taking title. Now, if you have such a clause, I will tell you that courts have been applying that clause in the declaration, and basically not requiring lenders to pay anything, any of the assessments that accrued prior to taking title. So take a look at your declaration, and if you have such language, you should consider discussing with legal counsel to amend that out and remove it from your declaration, so that if a lender does foreclose and takes title, then at a minimum, they would be liable to the association for the amount that's set forth in the statute. All right, quickly on financial reports. So each year the board has to prepare a financial report of the preceding year's financial activities. And that has to be done within 90 days after the end of your fiscal year. And then within 21 days after the financial report is completed, but no later than 120 days after the end of your fiscal year, the board has to provide each member with a copy of the financial report, or in the alternative, you can provide the owners with notice, letting them know that the financial report has been prepared and is available upon request at no charge. Now, the level of the financial report is going to depend on the annual revenue of the association, unless your bylaws require you to do a financial audit. So if you have express language in your bylaws that says the association has to do a financial audit, that is what you have to do. If you don't have an express requirement in your bylaws to do a financial audit, then your level of financial reporting will depend on these revenues. So for example, if your financial revenue is at least 300,000 but less than 500,000, then by statute you're only required to do reviewed financial statements. And then, obviously this is something that your CPA will assist with. Now, as of July 1st of 2024, regardless of the association's total annual revenue, an association with at least 1,000 parcels has to prepare audited financial statements. I'm not going to go into detail here, but just be aware that the owners can vote to raise the level of financial reporting. So if you're required by statute to do anything less than an audit, the membership can vote to require the association to do a financial audit. Similarly, if you are required to do a higher level of financial reporting and you want to reduce the level of financial reporting, you can request the membership to vote to reduce that level of financial reporting. Except that effective July 1st, an association may not prepare financial report at a lower reporting level for consecutive fiscal years. So just be aware of that. And then we talked about reserves. So if you're not required to maintain statutory reserves, the statute requires you to include these disclosures on limited proxies or any voting materials that go before the membership, just basically letting them know, hey, we're not maintaining statutory reserves. And essentially that means that you could be subject to a special assessment if there's a need for additional funds to address any maintenance or repair issues. All right, we're almost coming to the bottom of the hour. Let's quickly talk about contracts. And then, okay, we have a few more slides. All right. Contracts, just made some slides here about the ability of the association to contract, bidding requirements. Not really going to talk about this in a lot of detail. Just want you to be aware, if the aggregate cost of the contract is more than 10% of the total annual budget, and that includes any statutory reserves, then the association has to obtain competitive bids. Okay. Now, the statute does specifically exempt from the bidding requirements certain type of contracts, which we've included here. So contract with, for example, attorneys, employees, community association management or manager, engineer, landscape architect, you do not have to obtain bids. All right, estoppel certificates. Don't want to spend a lot of time, but I did put a lot of information here. There's at least 10 slides on this. Estoppel certificates will come into play when an owner is looking to sell their parcel, right? So if you recently purchased the parcel in the community, you will know that your title company will send a request to the association or management. That is called, an estoppel request, and they will request certain information regarding the parcel. And they will want this information basically in anticipation of closing. Okay, so if the association or your management agent receives a request for certain estoppel information, then within 10 business days, you have to provide the requested information. Now, I've included here basically what the statute provides for an estoppel certificate. So this is essentially information that would be requested from the association on a sale of a parcel. So the estoppel request will request information on the amount of regular periodic assessments, the date that the assessment is paid through, the date of the next installment, an itemized list of all assessments, special assessments, and other monies that are owed on the date of issuance, so forth and so on. It will even request information on any open violations here, number 2. So it's important that you want to note on the estoppel certificate any open violation. So for example, if an owner has made an unauthorized alteration and hasn't addressed it, you will want to identify that on the estoppel so that the issue is addressed by either the selling owner or the new owner who buys the parcel. They are put on notice that this is a violation and they're going to have to address it when they take title. If you don't identify this information on the estoppel, then you are essentially in a position where the buying owner can say that you've waived your ability to enforce any of these violations against the new buyer because you didn't identify it on the estoppel. Now, under the statute, you are allowed to charge for responding to these estoppel certificates, okay? And the statute currently provides that you can charge a fee not exceeding $250 if the selling owner is not delinquent to the association. Now, if the selling owner is delinquent to the association, you can charge an additional $150 on top of the $250 in order to respond to the estoppel request. Now, if the estoppel request is made on an expedited basis, and you provide a response within 3 business days of receiving the request, then you can charge an additional $150 fee. Okay. Let's see here. So just quickly here, also note that if the estoppel certificate is delivered by hand or email, they're good for 30 days from the date of issuance. And then if the estoppel certificates are delivered by mail, then they're good for 35 days. Okay, let me just quickly go through covenant enforcement. And I think that is the last major topic. So we'll talk about finding here. So as part of your declaration, you're going to have a number of covenants, restrictions in your declaration that you have a fiduciary obligation as a board to enforce. And you might have additional rules and regulations, prohibiting certain type of conduct that you have an obligation to enforce. So some of them might include, and I've identified them here, architectural standards, pet leasing, parking restrictions, certainly nuisance conduct. So you want to make sure that you uniformly enforce all your covenants and your rules. That means you enforce it against all owners, not just against selective owners, and that you also timely enforce this. You want to enforce uniformly because if you don't, next time you want to enforce the covenant against an owner, the owner could raise a defense of selective enforcement, which you may have heard, right? Where the owner says, hey, you can't enforce this against me when, Joe Smith over there is in violation of the same covenant and rule, and you haven't enforced this against Joe Smith, okay? And you also want to make sure that you enforce it in a timely fashion, and that means within a year from the date you knew or should have known of the violation, because if you don't enforce timely, then the owner can raise a defense of waiver. In other words, you've set too long and you didn't enforce anything from the date that you as a board knew or should have known of this violation. So now you are barred and can't come after me for this violation. And again, these are defenses. These defenses are not automatic. They have to be raised. But if these owners retain counsel that is proficient in this area of the law, then you will likely lose in enforcing these covenants. So some of the remedies, some of the ways that you can enforce covenants is through fining, suspension of use rights, suspension of voting rights. You might have self-help remedy in your governing document. And certainly there's always the pre-suit mediation and litigation in order to ultimately force the owner to comply. So we'll talk about fines and suspension of use rights. So the association has the right to fine and suspend use rights of an owner's tenant, guests, and invitees for failure to comply with the governing documents. Now, when you fine or suspend use rights for violations, okay, it's done basically in a 2-step process. So the statute says the board adopts the fine or the suspension, but it cannot be imposed unless there is a hearing before an impartial committee, at which the committee basically has to either ratify or reject the fine or suspension. Now, that hearing at which the committee will sit and hear the violation has to take place at least 14 days from the day that you provide notice of the hearing to the violator. Now, the statute would was amended in last year and effective July 1st. Now it says that the committee hearing must now be held within 90 days after issuing the hearing notice. Okay. So not only does the committee hearing has to take place at least 14 days from the date of the notice, it has to take place at least 90 days. So the committee has to be comprised of at least 3 members appointed by the board who are neither officers, directors, or employees of the association, or the spouse, parent, child, sibling of an officer, director, or employee. So yes, I recognize that for some of you, this might not be a viable remedy because you just can't get an impartial individual who's not a member of the board or an officer, employee, or anyone residing with any of them. So yeah, if this is not a viable remedy, I mean, that's okay. Then you're probably just, your only other options would be to address the violation through pre-suit mediation and litigation. Now, the role of the committee is not to negotiate the fine or the suspension. The role of the committee is simply a yes or no vote. It's to either ratify or reject the fine, or the suspension. Now, within 7 days of the hearing, the committee has to mail or email written notice to the violating party of the committee's findings related to the violation. And if there are any applicable fines, then you have to let them know when the fine is due. Now, if the violation has been cured before the hearing or in the manner specified in the hearing notice, then the fine cannot be imposed. The statute also says that if a violation is not cured and the fine levied by the board is approved by the committee, then the committee has to set the date by which the fine must be paid, which date must be at least 30 days after the delivery of the notice of the committee's findings. And then if a violation and the fine levied by the board is approved by the committee and the violation is not cured or the fine is not paid per the notice, then reasonable attorney's fees and costs can be awarded to the association if you're then additionally pursuing the violation. Now, the statute does say that the fine cannot exceed $100 per violation unless otherwise provided in the governing document. And then the fine may be levied on the basis of each day of a continuing violation, but cannot exceed $1,000 per violation in the aggregate unless provided in the governing document. So what that means is that unless your documents provide otherwise, you can impose a fine not exceeding $100 per violation. And each day that that violation continues, let's say you're a no pet community and you've sent notice of violation to the owner to remove the pet, and the owner doesn't comply, for each day that that pet remains in the home, you can fine up to $100, not to exceed $1,000 for that particular violation. Now, if your governing documents provide for a greater amount for the fine, then you can default to what your documents provide. Now, a fine of $1,000 or more may become a lien against the lot and can be collected through foreclosure proceedings if you have authority to collect fines as a lien. And that authority has to be expressly set forth in the declaration. So some of the older documents might not have that, so you would need to amend your declaration if you want to have the ability to collect fines as a lien against the parcel. Now, if you want to suspend use rights, again, suspension of use rights really will pertain to common facilities such as your pool and your community centers, etc. So a suspension of the right to use common areas and facilities cannot apply to the portion of the common area used to provide access or to utility services to the lot, and cannot prohibit an owner or tenant of a lot from having vehicular or pedestrian ingress to egress from the lot, including but not limited to the right to park. So it can't prevent an owner from going in or out of their home. Now, effective July 1st, the statute provides that notwithstanding anything to the contrary in the governing documents, the association cannot levy fines for leaving garbage receptacles at the curb or end of your driveway within 24 hours before or after the designated garbage pickup day, or for leaving holiday decorations or lights on a structure or other improvement on a parcel longer than indicated, unless such decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the parcel owner. That's all I have to say about that. All right, you also, as a board, have the ability to suspend use rights if the owner is delinquent on a monetary obligation to the association for more than 90 days. Okay, now this, if you are suspending use rights for a delinquency, this is something that the board can do at a board meeting, and you do not need the committee to ratify the suspension. Okay. Now, for the suspension to take effect, the notice of the suspension has to be mailed, hand-delivered, or emailed to the owner, and if applicable to the occupant, licensee, or invitee. And then a suspension to use common areas and facilities does not apply to the portion of the common area used to provide access, utility services, and it cannot prohibit an owner or tenant from having vehicular or pedestrian ingress to or egress from the lot, okay? As well as the right to park. You can't suspend the ability of the owner to park. And then the suspension ends upon full payment of the delinquency. The board also has the option of suspending voting rights, okay, if the owner is delinquent for more than 90 days. Now, there was a case law that has come out that has recently taken the position that in order to suspend voting rights, the association has to have express authority in the declaration, or you need to have Kaufman language. So in an abundance of caution, if you want to have the ability to suspend voting rights for delinquency, amend your declaration to give you that authority. But the effect of suspending voting rights is that if the voting interest is suspended, it's not counted towards the total number of voting interest for any person, including the number necessary to establish quorum or required to approve an action. So what that means is, let's say you're trying to get membership approval on an important amendment. And let's say you have 100 parcels in your community and you have properly suspended the voting rights of 10 owners. Well, if quorum is 30%, and you've suspended voting rights of 10 owners, then quorum will be established based on 30% of the 90 owners, not 30% of the 100. And similarly, if your documents require a majority vote of the owners to approve the amendment, then that vote would be based on a majority of the 90, not a majority of the 100. Okay. The next slides really talk about basically pre-suit mediation. I'm not going to go into details, but just note that certain disputes between the association and owners have to go through pre-suit mediation before the association can file a lawsuit. And we've identified here in these slides what disputes require pre-suit mediation. Certainly, any covenant violation will require pre-suit mediation. And then we've outlined here basically, you know, the steps involved in seeking pre-suit mediation. This is really more for your legal counsel to note, but just so you are aware of the process, they are included in the slides and you can read them at your leisure. And then there is there is the option of exercising self-help. Self-help refers to the ability of the association to basically take on the obligation of the owner. So for example, if owners are responsible for mowing their lawns and an owner has neglected to mow their lawn for, let's say, a month, and the grass is, 12 inches tall, and the documents give the board the ability to exercise self-help, then you have the authority, the right to go onto the lot, mow the lawn, and then potentially recover the expense from the owner. Well, just be aware that case law has come out that basically says that if you have the self-help remedy in your declaration, then you have to at least try to exercise the self-help before you bring legal action against the owner to force the owner to mow the lawn in this particular case. So you wouldn't be able to pursue legal action against the owner until you've at least tried the self-help remedy. Now, the drawback of this is that, self-help remedy is not always the recommended remedy, right? I mean, there is definitely exposure to the association, not only to liability, potential damage if you damage something else on the lot, but you just don't want to be put in that position where you're confronting an owner by showing up with, a contractor to do work that the owner's required to do. So self-help remedy is not recommended in all instances. It should be exercised on a case-by-case basis, and certainly encourage you to discuss this with your legal counsel. And so just be aware that if you do have self-help remedy in your declaration, you have to exercise it before you pursue legal action. If that's not something that you feel comfortable with, or you don't think this is in the best interest of your community, then discuss the possibility, the option of removing self-help from your declaration, so that any enforcement of a covenant, you really have to pursue legal action against the owner. All right, I think that's it for today's slides, at least. Unless Jeff, you have any comments, I'll go to the Q&A.